Defendant's motion eliminate to allow evidence of lack of bias.
Oh, I've been waiting for this one.
For the Commonwealth.
I've been really interested in hearing the arguments on this one.
Who's arguing that for the Commonwealth?
That's the defense's motion. So
Jackson or Unetti? Or no, Commonwealth. Wait, lack of bias. Wait, hold on. I'm sorry. I must have missed something.
First, Your Honor.
No, it's the defense motion. The defense should go first.
Defendant's motion. Mm-hmm. The Commonwealth opposed it.
You would ask who's arguing that for the Commonwealth.
They
I'm
opposed
sorry,
it?
defense motion. Okay.
Yeah, and Judge, you said for the who's arguing it for the Commonwealth? So the Commonwealth stood up and went, "It ain't me, Your Honor." Sometimes you're the one creating the problems. Like when you made everybody renumber the exhibits last trial. Sometimes you're creating the issues yourself.
Excuse me?
I could go first if you'd like.
I'm fine with him going first if you'd like.
Okay.
weird.
Excuse me?
I could go first if you'd like, whatever the
I'm fine with him going first.
Fucking hell.
Okay.
He says it's the defendant's motion. Commonwealth opposes it. Then she goes, we'll start with the Commonwealth.
This has to do with letting the jury be told that ARCCA was initially hired by the U.S. Attorney's Office because they were confused during the last trial.
Who's on first? The judge apologized. Everybody seems done today. Everybody is done today. Someone just go. Technically, it's the defense motion. They go first. The Commonwealth is like,
the
whatever.
heart of this motion is that the defense would like to introduce the ARCCA witnesses as witnesses that were employed by the federal government.
Correct.
I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report.
As they were.
Uh-huh.
And then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation.
This is for cross-examination.
All accurate.
I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have
You want to know what causes a trial within a trial in this trial? Jen McCabe. Jen McCabe causes a trial within this case. ARCCA does not.
Why this investigation was initiated, what the purpose of it truly
Why
was,
does that matter?
the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications
Nothing to do
between
with
the federal
ARCCA.
government.
He has zero evidence of this. He just gets up in open court and spews nonsense. You know what we will never know? We will never know the true relationship between the Norfolk County District Attorney's Office, Michael Marcy, Mr. Lally, and yourself, between the relationship between you and the Alberts and the McCabes. We will never know the true depths of that relationship, but based on the hostage video from August of 2023, we can kind of take a little guess.
We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCCA and what, if any, impact the defense had on ARCCA witnesses at the time they did the investigation.
That's what makes this case so weird, is that this state prosecution office is, it seems, nervous or looking at it like in a negative way that the federal prosecutors would even talk to this defense team. That's what's so unusual about it to me.
And it's humorous. I mean, it really is funny, for me at least, it is really funny to hear a state prosecutor say, we don't know what kind of relationship that these people have with the U.S. Attorney's Office. I mean, I've never heard a prosecutor say something like that. That just was really, really off the wall.
What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case.
You want to talk about relationships that we're never going to know about? Let's talk about that. But do not get up in open court and accuse the defense attorneys of colluding with the U.S. Attorney's Office with zero evidence to back that up. Really, dude? Really?
Gee, it's almost like he's making an argument that someone had influence on the investigation. Isn't that strange? Wouldn't it be odd if people had influence on investigations? Wouldn't
Maybe
that be
somebody
kind of
who might be
improper?
found to have bias?
I don't know. But to say that an investigation went forward with people that probably shouldn't have had contact with the investigators because the investigation would go in a certain direction. But, maybe that's just projecting.
And so clearly there is a undefined relationship between the defense and the United States Attorney's Office
Clearly
around
now.
this time of this investigation.
So what?
We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. And so it would be misleading to have ARCCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts in report was wholly and entirely objective. Just to give one point.
Do you agree with that? Like, is that misleading to say the federal government hired them to do these experiments?
It's not misleading.
That's
The
what he
federal
said. He said
government-
it's misleading.
Well,
I don't understand how it's
the federal
misleading.
government did hire. It's not misleading. Well, again, are we talking about facts? Are we talking about opinion? That's a fact.
Yeah.
There's no
you
doubt that's a fact.
You mean it's a fact that the federal government hired them?
Yes.
Right. And it's his opinion that they're not neutral.
Right. That's an opinion versus the fact.
Yeah. And this part is starting to really piss me off about Brennan.
Oh,
I'd
every time he
welcome
says,
I'd
like,
welcome ARCCA.
he's so disingenuous about that.
I want this. I want this.
And the thing is if Bev actually had some spine,
she'd say, all right, motion denied.
That's exactly what I'd be doing as a judge.
Right? Tell me you
I'm
haven't
not
been in
trying
front
to
of
deny
judges
them
like
their
that.
lawyer. You're not, Brennan? Sorry, are you confirming that you're not? Okay, motion denied.
And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it.
So they don't
Other Rule
actually have a
14 discovery,
relationship and they can't comply.
Obligations have not been complied with.
Does
We've
that
received
answer your
no information
question?
since that production on February 13th. Nothing.
Let me tell you how cooperative the feds
I
are.
think it sets a bad playing ground.
Yeah, the feds will have sent a very nice PFO letter.
Like, oh, that's cute. You want information?
The inculpatory evidence.
The state had every opportunity to give that information to the feds. They act like the feds wouldn't have taken it. They would have taken anything the Commonwealth wanted to give them at any time, at any place. I mean, they probably all have to do is walk across the street. It's ridiculous for him to say that he was cut out of the process when he could have inserted himself into it and he didn't want to.
I'm not one to just cast aspersions on representations made in court, but I haven't seen. All right, this is the problem with that. I love this. We don't have any Rule 14 discovery. I love that. I'm really tired of this. I really am tired of this. It's not just casting aspersions. It's absolute statements. It's absolute statements of there's been nothing. And they'll say nothing. There's been nothing. And it's like, well, here's the thing. So I understand that you can get hyperbolic in argument. I do get that part. But there's a difference between like making a hyperbolic statement from time to time to emphasize an argument you are making, getting called on it and then correcting it, and making it during every single argument you make. And I'm really frustrated with it.
Well, and that was the accusation he made for the defense, that they went to the feds. They brought this to the feds. They tried to push this. And then the language changes when he talks about the Commonwealth. We weren't invited to the party. Well, nobody was invited to the party. The defense wasn't invited either.
Right.
It's wild.
So to say that he has no Rule 14 discovery, that was refuted by the very last argument we had in the very last motion, where they said there's been this volume of information turned over. That, Mr. Brennan, is Rule 14 discovery. You might not have what you believe is complete Rule 14 discovery, but don't say, look right there, the transcript got it. Don't know that because we don't have any Rule 14 discovery. That is not correct.
It's a situation where I think he really is trying to make it look as bad as possible to keep the witnesses out. That's all it is. All it is trying to get this judge, because judges inherently don't want their trials to become circuses. This trial is already bad enough. So this judge is not going to want this to become just to explode into the federal investigation. So he's trying to tell the judge, hey, judge, look, keep these guys out so we don't explode this into talking about the federal investigation.
To know or inquire as to why the defense did not call a witness. That is no.
He's my favorite. Don't tell the others.
Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCCA witnesses became involved in.
Can you remind her that they weren't allowed to testify about the medical cause of injury because somebody didn't have a PhD, but yet the dog behaviorist is now allowed to testify? So can we let the ARCCA witnesses do their job the way we saw in like the Paltrow case? Yannetti, can you bring that up too? We'd love to see that.
Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions.
But did you provide?
But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that
I think it actually hurt.
Excluded mention of.
He's going to get there. I think he's going to get there.
The Department of Justice and the U.S. Attorney's Office, because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate,
And
right?
but the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCCA was hired by Ms. Reed's car insurance or home insurance company.
I thought it was helpful to the defense to say that none of them hired, but what we've seen in the interviews jurors have given is that it actually kind of hurt those witnesses because we had more information than the jury did. And sometimes it's hard to filter that out of your brain. And the jury was trying to fill in the gaps about who would hire them. And we're starting to fill in the gaps about insurance companies and what have you.
And also the reason for Karen not being acquitted of counts 1 and 3 is because your instructions were so messed up and so confusing and so blatantly wrong that we are now having to undergo a second trial on counts 1 and 3 because of your instructions. So they didn't even understand reasonable doubt, apparently.
So it's helpful to the defense to know what the jury was thinking so they can try to fill in those gaps a bit more, but without being able to say the federal government hired them, which I do think could be too prejudicial in this case. It left them in a weird position where they're like, we didn't hire them, the Commonwealth didn't hire them, but then the jury is going to come up with their own answers, and those answers are probably not going to be right.
And they did speculate. We know that now because the jurors have spoken out. And they said, well, we didn't know who hired ARCCA, so we just thought it was either Karen's insurance company or car insurance company or Turtle Boy. And so we just disregarded it.
If Ms. Reed's insurance company had hired ARCCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that
She's already telling us how she's going to rule. If I allow, and I'd be very surprised if I did. Oh, Auntie Bev, your bias is showing again. The world is watching, babe. The world is watching. What are you doing?
this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into.
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you
court's, like,
could you answer
answered
that
that.
now, and then I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh, you
If
just said
I
it's
can-
late. Hold on, you just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Look at Aiden's face.
God.
Jeez, Bev.
Me and my husband, when we're hungry and we're trying to figure out what to do for dinner. That exchange. But you just said you didn't want.
Is it so out of the realm of possibility to allow these attorneys who have their arguments in some sort of logical fashion, unlike your boy Brennan there, to make their argument and their oral argument and their presentation in the order in which they have written it that makes the most sense, that is chronological, and she just really had to have a fight with him in open court? I'm embarrassed. I have secondhand embarrassment for her.
I just did the Bev side, but she hates all of the pushback and so forth. So,
But it's the
Yeah, I
passive
don't-
aggressive.
The judge is telling the defense, we told the jury not to speculate. And the judge is like, okay, but I have a question now. Can you speed up in your argument and answer the question I have now? I'm not going to write it on a notepad. I want the answer now. And he's like, I'm fucking getting to it. Just like the jury. Your Honor, don't speculate. Let the man finish.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial.
Can they get in and cross-examine him about these inculpatory statements or evidence? Absolutely. Good cross-examination, totally legitimate cross-examination. Can they get into the fact that the feds closed the investigation? I do not think that that's legitimate.
We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation.
Yeah, but the jury, in all honesty, is going to speculate why the DOJ hired them. I mean, like there's no escaping the jury speculating. Even when you tell them they were hired by the DOJ, that's going to make them speculate, well, why? I mean, there's no avoiding the speculation aspect of it. That being said, the jury needs to know who hired them.
And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice.
It becomes
my
a
client.
black hole.
Thinking that they were potentially hired by an insurance company of Ms.
I mean,
Reed.
they can ask questions around
really
that.
perverts the truth in this case.
But it becomes a
it's unfair
black
to my
hole.
client.
I mean,
that-
but if she at least makes it clear that, look, you've heard this evidence that they were hired by the DOJ. The last thing I want you to do is speculate as to why. I can
Right.
promise you it's not relevant. It doesn't matter. It's only for the purposes of you understanding that they were not hired by the
Either side.
Right.
Is that investigation being open or closed relevant to this trial? In my opinion, no. What is relevant, because the Commonwealth wants to ask it and they should be able to ask it, is the bias or lack of bias of an expert witness. Well, the relevant response is the feds hired them to do this experiment, to come up with this report, to come up with their opinions. That is the end of the relevant information, in my opinion, to this trial.
They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence.
As opposed to taking a drunken look at things,
This is what I-
which
this
is the
is what I-
job
this is
of
what
the
I mean,
Canton
is it-
Police Department.
Wait, you're telling me that the U.S. Attorney's Office did what prosecutors are supposed to do and try to figure out what the fuck happened. And they went to an expert and said to the expert, hey, you're an experty expert. You work with like the NHL and the military, and this is your shit. This is what we know. Can you tell us what the fuck happened? Thanks.
The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCCA on cross-examination for the discovery that they were not provided. That was patently unfair.
It's like somebody was looking for answers. And I think the jury should hear that.
But what it really would, again, be the truth, probably, is that they got paid $200,000, and this $26,000 is a drop in the bucket, and that their experiments and their opinions and all that stuff was paid for by an independent third party who had no bias or interest in the results of the trial. That's an important point. And again, Brennan knows what he's doing. He knows what he's trying to do because he knows how that's going to benefit the defense.
Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination
100%.
material. He's free to explore whatever he wants on cross-examination.
Your Honor, we're the defense. The discovery we get in this case, the police reports, that comes from the government. And if the government, in this case, the Commonwealth, or the DA's office, or law enforcement, or whatever, is a target of the investigation, they're going to get the case file from someone else. The feds asked for my case file. We have nothing to hide. We sent it to them.
So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCCA came into the case.
Okay. Any follow-up?
Yes.
He shouldn't get follow-up. It wasn't his motion.
Right. Yeah. That makes no sense.
Karen agreeing they can have the whole file. She's got nothing to hide.
Respectfully, the Commonwealth is not to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth.
And the 20,000, if he gets into that 20,000, the defense should be able to say, okay, what was that for? What did we pay you for?
Yeah.
And they're going to say, so we did not pay you for your opinions. We did not pay you to do the experiment. We did not pay you to review the evidence. Somebody else paid you for that. That should all come in.
Perjury, misleading. It really get.
I do not think.
I'm not casting aspersions, but perjury.
If you're completely unprepared to cross-examine them, it's because you're an idiot.
Yeah, at this point, it's a you problem.
Yeah.
He's like, I'm completely unprepared to cross-examine them, Your Honor. And the proper response from the judge would just be to lean forward, tap the mic, and say, skill issue.
Closing the investigation, which is not an indication of innocence. It's not an indication they didn't find any wrongdoing. We have a statute of limitations that hasn't run. So they could always open the investigation again and come after them. So it's not evidentiary that an investigation at this time is closed. But again, it is certainly legitimate for him to go into all the stuff that he thinks proves his case when he's cross-examining the ARCCA witnesses.
So if the defense intends to call the ARCCA witnesses, we need to have a voir dire next week. All right? So
they're going to have to fly out.
It's under advisement.
Can I just ask?
I didn't catch that. I just heard Elizabeth Little say, well, what?
I missed the what?
What? What? We're going to do this again?
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later.
Auntie Bev doing Bev stuff. I don't exactly understand what Bev's reasoning is.